afternoon, everyone. Thank you for joining us for today's online talk, which will be starting shortly at 3 p.m. For those of you who are here early, thank you for waiting patiently. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Navigating Divorce Obligations, Insights on Varying and Enforcing Decree Nisi Orders. My name is Siti Aisyah binti Abdul Rahim, a pupil in Chambers at Wing Kwai as Associates. And I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Wing Kwai and Associates is a mid-sized law firm that was founded in 1985 by Dato' Wing Kwai. Our able team today comprises of 28 lawyers and support staff of 35. Dato' Ma is today's consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small, medium enterprises, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment and industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice group includes some of our focus areas which are supported by talents from both our corporate and dispute resolution team, including the ASEAN-China desk, construction, foreign direct investment, real estate, sports, and esports. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some which were also broadcasted live. But with COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Our recent online talk was held on the 31st of May on the topic of Industrial Court versus Labor Court, understanding the process, the law, and recent amendments to protect your rights. And please do join us for our upcoming MWK online talk on the 12th of July on the topic of contentious probate proceedings. Before I continue, allow me to introduce our speakers for today. We have Rachel Ng, which is an associate in our Dispute Resolution and Individuals and Families departments. She holds the Bachelor of Laws from the University of Northumbria, Newcastle, and she was admitted to the Bar of England and Wales in 2020. She was then admitted to the Malaysian Bar in 2021, and her areas of practice include construction, general litigation, family law matters, citizenship matters, will writing, and probate and administration matters. Our next speaker is Ms. Kirthika Padmanapan. She is an associate in our Dispute Resolution Department. She holds first-class honors in Bachelor of Laws, University of Leeds, United Kingdom. She was called to the English Bar in 2021 and subsequently admitted to the High Court of Malaya in January 2023. Her areas of practice include strata management, family and citizenship matters, employment law, and criminal defense. Our talk points today are methods of enforcing a decree nisi, case studies on enforcing a decree nisi, situations in which a decree nisi may be varied, and case studies on varying a decree nisi. So for the first 2 points will be addressed by Ms. Rachel, and the later points will be addressed by Ms. Kirthika. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be given later at the end of this talk.
Thank you, Aisha, for the wonderful introduction. Hello, everyone. Good afternoon. So today I will be speaking on the first 2 talk points, the first being methods of enforcing Decree Nisi, and the second one will be case studies on enforcing Decree Nisi. So what is a Decree Nisi? To be very general, Decree Nisi is usually granted after the conclusion of divorce proceedings. So it is essentially a court order, and the terms in the Decree Nisi usually relate to the following. So it's either maintenance of children or ex-spouse, terms for access of one parent to the children who is with another parent, and also terms relating to the division of matrimonial properties. Enforcement of Decree Nisi, this will happen when one party doesn't comply with the terms which are set out in the decree. So the most common method of enforcement is committal proceedings. However, for situations where there are terms for payment, such as payment of child maintenance, where one party does not make payment, the other party can enforce the Decree Nisi via these 2 methods. One being garnishee proceedings, and the second one being applying for an attachment of earnings order. I will start with committal proceedings first. Committal proceedings are commenced for contempt of court to obtain an order which is called the committal order against the defaulting party. So a committal proceedings are suitable in situations where the ex-spouse does not comply with maintenance terms. Your ex-spouse does not allow the other spouse to exercise access rights to children, such as there are access terms, as in maybe access to children from Saturday to Sunday, and the spouse having custody of the children does not allow you to see your children, or will tell you things like, oh, the children are busy and things like that. So another situation would be where the ex-spouse does not comply with the Decree Nisi terms to sell or to transfer matrimonial property. And also another situation is spouse does not comply with other performance terms in the Decree Nisi. This can be transport of children, or does not agree regarding the schooling arrangements for children. What happens after committal proceedings? So on a successful application, the court will grant, which is what we call a committal order for the party in contempt being a party breaching the order, to purge his contempt, as in comply with the order, or to be committed to prison. However, if the party breaching the order purges his contempt, as in he complies with the order, say if it's an order for payment, he makes the payment, or if it's an order for access to children, he allows the access to children and does not stop you from seeing the children, the party breaching the order, or we like to call it party in contempt, will not be committed to prison. So the second method of enforcement is garnishee proceedings. So garnishee proceedings is a method of enforcement suitable for Decree Nisi terms where there are payment of maintenance or lump sum payment involved. So this, we call it an order, a garnishee order. The court will compel a third party, usually a banking institution, to pay this lump sum to the party who is owed. So the banking institution will directly pay the money from the person's account to the party who is owed, basically the creditor. This method of enforcement is only recommended where the sum of maintenance or the sum pursuant to the Decree Nisi owed is a lump sum. Why I say it's suitable when the money owed is a lump sum is because it will be tough and costly for one party to go to court each time the other party does not pay. Say the maintenance is for 1,005 ringgit a month. You can't be going court every month to get this payment of 1,005 ringgit. It will be very costly on the party applying, especially legal costs and also court disbursement. So what do you do when you have the order asking the other party to pay monthly maintenance? So you can go for what we call an attachment of earnings order. This is similar in nature to garnishee order, but this is provided under the Section 4 of the Married Women and Children Maintenance Act. You can get an order. The court will order the employer of this debtor to pay you from the salary each month. So it is quite straightforward, and it is a remedy provided specifically for these kind of situations wherein you are unable to recover monthly maintenance payments from your ex-spouse. The procedure, to put it simply, is that you will go to court and you will require the person who is the employer of your ex-spouse to come to court and give a statement regarding the earnings of your ex-spouse. So it can be statements such as the payslip, can be attached as proof, and thereafter the court will look at the payslip, consider the expenses of your ex-spouse, and thereafter give an order for a certain amount to be paid each month to your account directly by the employer. This will circumvent the situation wherein your ex-spouse doesn't pay you. So this is recommended, as I mentioned before, because you won't need to go to court each time your ex-spouse fails to make the payment, and the money will come straight from the employer. So as long as your ex-spouse is earning from this particular employer that you have this attachment of earnings order against, it will be enforced. So moving on, I will be looking at some cases on enforcement of Decree Nisi. For these cases, these are mainly on maintenance terms. So the first case would be the case of Ye Chuan Hui against Serena Lim Pat Yen. This is a case on the attachment of earnings. So what happened was the Decree Nisi provided a maintenance of 14,000 a month for the two children of the marriage. The husband actually filed an application to vary the Decree Nisi, but this application was dismissed. The husband then filed an appeal against this decision to dismiss his application to vary. Husband also filed another application to set aside the Decree Nisi. So during the whole proceedings, the husband actually failed to make a lot of payments for maintenance, and there was an outstanding amount of about 400,000 ringgit. So after the wife filed the application for attachment of earnings, it was discovered that the husband was employed under a 2-year contract. And the husband's employers came to court and testified that the husband's monthly salary is 23,000, about 23,000, and that the husband's employment contract will be renewed and will end on the 1st of April. I believe this case was heard about 2-3 months before the husband's employment contract was due to end. So the court, looking at the situation for the attachment of the husband's net earnings, meaning all of the earnings for the months of February and March, on the basis that because the husband has the financial capabilities to file appeal and appoint lawyers and file multiple suits in the High Court, husband has the financial capability to cover his living expenses, even though the attachment of earnings order is for the full earnings, meaning the full 23,000. So the court also observed that the husband did not seem to care for not paying the maintenance of the two children. And the court decided that if this order was not made, the wife would not be able to enforce the decree and will not be able to recover the arrears of the maintenance owed. Because from 1st of April onwards, since the husband's contract with the company would end, the husband would no longer be under the employment of this company and would have moved to another company. And then it is likely that the wife will have to file another proceedings for attachment of earnings against this new company. So this is a good example of how attachment of earnings work. So the next case is committal proceedings. So for this case, it is quite simple. There are payment terms. Husband is supposed to pay 2,000 ringgit to the wife, and husband is supposed to settle this particular loan, which was taken under the wife's name. So what happened was the husband failed to comply and was also not present for the first hearing of the committal proceedings. So subsequently, the court issued what we call a warrant of arrest so that the husband is present in court for the next hearing. So at the hearing, the husband informed the court that he wasn't aware of these committal proceedings. However, he confirmed that he was served with an envelope containing the court papers for these committal proceedings, but he refused the service. Husband is aware of his obligations under the Decree Nisi, and husband agreed with the court that he hasn't been paying any child maintenance since the divorce. However, the husband was not able to provide a reason for not paying and informed the court that he is only able to pay 300 a month as child maintenance due to his current job, as his current job wasn't permanent and he was looking for a new job. Considering the circumstances, the court held the following. The court held that the husband was not able to offer any sort of concrete evidence why he was not able to comply with the decree. And the husband had also contradicted himself when he said that he was not aware of the committal proceedings and yet he was present in court. Husband failed to file any affidavit to address the allegations of contempt despite being given time to do so, and did not challenge the committal proceedings. The court decided that the husband had shown total disregard and defiance to the rules and the proceedings. The court then sentenced him to be imprisoned until he purges his contempt, which was to pay the maintenance owed and also to settle the loan which was taken under the wife's name. Moving on, we will be looking at cases on enforcement of Decree Nisi for custody or access terms. So this is a particularly interesting case that multiple applications considered and decided in this one case. So what happened was the decree initially provided custody of the child to the husband, but subsequently the wife managed to vary the decree and the custody was then granted to the wife. So the husband appealed against this variation, but subsequently withdrew the appeal. And on the order of the Court of Appeal, the court ordered the child to be handed over to the wife at the court itself. So husband complied with the order and handed the child over to the wife. However, about 2-3 weeks later, the husband literally walked past a restaurant and saw the child having lunch with the wife at the restaurant. And then husband decided to go into the restaurant with some friends who were equipped with walkie-talkies and camera. So we can tell that the husband was intentionally going in and tried to get the child to come back with him, which the child then actually followed the father. The full circumstances of the case was that the child was crying because there were a lot of people being the husband's friends, and there were a lot of screaming and shouting, and the child was scared. So the child followed the husband, and subsequently the wife, not being very happy with the child following the husband despite the order, filed this application for leave to take the child out of jurisdiction. The wife was living in London and working in London, and also for the husband to hand over the child's passport. The wife's solicitor also raised a preliminary objection during the hearing, stating that the husband should not be heard as he was in contempt of court by taking the child away from the wife. The court was on the wife's side and held that yes, husband was in contempt of court and that he should not be heard. The court then ordered for the husband's solicitor to leave the courtroom and heard the wife's application for this leave to take the child out of the jurisdiction. So in deciding the wife's application, the court was of the view that the wife should be allowed to take the child to London, as the wife was in a better position financially to look after the child. If the child were to be left with the husband, would have left the child to be looked after by his sister and also her husband. It got so bad that the child was calling this husband's sister Mama. It was very clear that the husband wasn't personally taking care of the child himself. The wife at court also provided a proposal on where the child would be enrolled in school in London, and also informed the court that the wife will have more time to look after the child. The wife was a restaurant manager in London, and the wife's working schedule is also flexible. The court was also of the view that the husband was not a good role model, as the husband had taught the child to hate the wife and has disregarded the court order by taking the child away from the wife. So after considering all the circumstances, the court allowed the wife's application. So the wife is allowed to take the child to London to live with her, as it is in the best interest of the welfare of the child. The husband is allowed supervised access to the child in London. And if he were to exercise those access rights, he would be bearing all the traveling expenses. The wife is to bring the child back to Malaysia every year during the child's school summer holiday or during the Christmas seasons for a period of 1 week each time. And the husband is also allowed supervised access to the child during her return to Malaysia. So the court was of the opinion that the access can be varied should the husband prove to be trustworthy later on and proves to be reliable regarding the access to the child. So usually cases would end here, but there are more to this case. After the decision, the husband was actually ordered to hand over the child and the child's passport on the 9th of September. Husband did not show up in court, and his solicitors were also unable to reach him. The court then fixed another date for the husband to comply with orders. So on this next day, the husband appeared in court, but informed the court that the child cried and refused to come to court. Husband also informed the court that the passport is with the husband's mother and that he does not have the time to collect it from his mother's house. So the court, considering that the husband has repeatedly refused to comply with the court's order, the court held that the husband was in contempt and fined the husband 20,000 ringgit in default 2 months imprisonment. The court also ordered an additional fine of 400 for each day that the husband fails to comply with the court order. So based on this case, we can see that the court is very strict on its orders and that refusal to comply will amount to contempt of court, and the court can unilaterally order for committal without even the wife filing an application. So the next part of this talk will be the variation of Decree Nisi. I will pass on to my colleague Kirthika, who will be bringing you through the slides.
Thank you, Rachel, for walking us through the different methods of NISI. I'm now going to go through the different ways in which you can vary a decree NISI and the situations in which it can be done. And then following which I'm going to go through a few cases in which variation of a decree NISI was successfully obtained and a case where it wasn't. Okay, in terms of variation of a decree NISI, the word variation itself is very simply put a change in a condition. And when you look at variation that is allowed under the LRA, which is the Law Reform Act, which is the primary legislation governing civil marriages and divorces, there are three situations in which, or rather, there are three main conditions under which variation can be done. One is provisions relating to the maintenance of a spouse, which is provided for under sections 83 and 84. The second is provisions for maintenance of children under sections 96 and 97. And the last one is provisions for the custody of children, also under sections 96 and 97. Okay, so in terms of section 83 of the LRA, and in relation to provision, the power for court to vary previous orders for maintenance, basically it can be done at any time in situations where the court is satisfied that the order was based on misrepresentation, mistake of fact, or where there has been a material change in the circumstances of the proceedings. I will talk briefly about the misrepresentation and mistake of situations regarding misrepresentation and mistake of fact. The focus of today's talk will be situations whereby there is a material change in circumstances. The other provision in relation to where courts can vary maintenance is where there's been a prior agreement in relation to maintenance, and this is provided for under section 84. Similarly, the court may at any time vary the terms of the agreement, and the only difference is that here, whereby the court is satisfied that there has been a material change. So previously, whereby there were three factors, i.e. Mistake, misrepresentation, and material fact. However, when it concerns agreements for maintenance, the main factor that the court will catch where there has been a material change. The provision with regards to children, i.e. section 96, provides for the court to vary orders for custody, and similar to provisions for maintenance, for spousal maintenance. Again, there are these three situations in which the court can vary a decree nisi: misrepresentation, mistake of fact, or where there has been a material change in circumstances. Section 97 is also worded similarly, and it relates to where the court can vary an agreement for custody or maintenance relating to children. And similarly, it can be done. The only difference between this and the previous section relating to spousal maintenance is that here the primary concern of the court is where it would be reasonable to make such a variation, and where it's in the interests of the welfare of the child to do so. Clearly here the focus is on the welfare of the child. Okay, so what exactly is misrepresentation? The term misrepresentation itself is not defined in the LRA. However, the Contracts Act does define misrepresentation to include these situations, such as whereby there is a positive assertion that is made by an individual, even though that person knows that the assertion made is untrue, where there is a breach of duty, whereby there is without an intention to deceive, but it gives an advantage to the person who is making such an assertion, and whereby you cause a party to an agreement to make a mistake as to the substance of the agreement. So you are essentially inducing someone to make that mistake. So examples of this situation of misrepresentation would be whereby you conceal your wealth or you conceal a source of income during the divorce proceedings. And to expand on this further, such a situation would include, for example, when a husband and wife file a joint petition for divorce. So they mutually agree to file a joint petition for divorce. And in the petition, the wife agrees on this maintenance sum of 1,000 ringgit a month, because based on what the husband told her, he can only afford this 1,000 ringgit a month as per his income. And despite the fact that this 1,000 ringgit is not enough to cover the needs of the wife, she agrees to this 1,000 ringgit based on what conveyed to her by the husband. Subsequently, 6 months after the divorce order was granted, the wife then discovers that the husband has a separate source of income, which wasn't disclosed to her at the time of filing the joint petition. And here, obviously, the husband would have concealed this separate source of income and concealed it not only to the wife, only from the wife, but also to the court, naturally, because it was concealed during the time of the joint petition. So as you can probably tell, under such circumstances, this would amount to a misrepresentation, and the wife would then be able to apply to the High Court to vary the maintenance order and to increase the monthly payable sum by the husband based on his misrepresentation. What exactly is a mistake of fact? Now, similar to misrepresentation, the term mistake isn't exactly defined under the Law Reform Act, but it can include situations where there is unconscious ignorance or forgetfulness as to facts, which are material to the contract, or at that time, you didn't really believe that particular fact existed. So to clarify this, basically, it's essentially a situation whereby either one or both parties involved have a mistaken belief as to an essential part of the agreement. So in this case, if both parties or one party mistakenly have this belief in relation to a key part of the divorce order, for example. And this is distinguishable from misrepresentation, because misrepresentation is whereby one party is induced to believe a particular fact by another party, and that was seen in the previous example that we discussed. So an example of a case law whereby a mistake was sufficient to essentially vary the Decree Nisi is this case of Gisela Gertrude, whereby the wife had initially obtained for a maintenance order against the husband for monthly payments of 2,000 ringgit for the wife, maintenance payments, and 1,000 ringgit maintenance for the child. 2005, which was obviously significantly later than when the divorce order was originally filed, the husband filed an application to rescind the order and to reduce the maintenance for the child. Essentially, rescission of the order basically means that he no longer has to pay maintenance to the wife. And obviously here he applied to reduce the maintenance of the child. When it went on appeal, the Court of Appeal basically held that maintenance of the order granted by the lower court was based on a mistake of fact, because the husband simply did not have the funds to actually pay the wife as per the maintenance order before 2004. And these were the reasons stated. First of all, he was bankrupt from October 1987 until January 1998. He was in prison, and obviously when during his imprisonment, he wouldn't have been having an active income. So he was in prison from 1995 to 1997, and only from 2004 onwards was he gainfully employed. So following this discovery by the court, maintenance payable to the wife was then varied from November 2004 to February 2009 to 1,000 ringgit a month, and 1,500 ringgit from March 2009 onwards. And the amount of maintenance payable to the child remained unchanged. So despite the fact that all of these situations had occurred, as you can see, the court still did not change the maintenance payable with regards to the child. So you can see that even though the court does take into consideration a change in a situation, especially of fact, the court is usually quite reluctant to change that sum, because the maintenance sum is usually based on some calculation of cost. So even though that there was this sort of change in situation, there was a very minimal amendment to the maintenance payments. Okay, so in terms of a material change in circumstances, usually the most common ground relied upon in applications for variation, simply because it's quite common for there to be a change in circumstances once a divorce order has been granted. So this term material change is very clearly something that has to be a significant change, and it cannot be a very minor or a very simple change. So the proper approach for courts to adopt is usually to start from the original maintenance order, to examine the changes, whether it's a financial change or otherwise, and then reevaluate the situation and see whether a variation needs to be done or not. And certain examples of a material change of circumstances include unemployment or retirement, an accident or deteriorating health condition, and this can be something that is lifelong, and a change in financial circumstances, which is quite often the most common one that we see. Okay, so in terms of variation, there are a few terms that cannot be varied. And Section 76 of the Law Reform Act provides that the court shall have power when granting a decree of divorce to order the division of assets between parties. Now, even though on the face of it, this does not say that this term cannot be varied, basically in the case of the federal court, in the case of Manokaram Anak Lelaki Subramaniam, held that Section 76 is one of the few terms in which cannot be a variation. So basically, Section 76 relates to the division of marital assets, matrimonial assets. And so this is what the court said when in relation to the fact that this divorce order could not be varied. Basically, the court said that in Section 76, it is clearly provided the power of the court to make an order for the division of the matrimonial assets can only be exercised when granting the decree of divorce and at no later stage. So basically, once an order in relation to the division of matrimonial assets has been done, it cannot be varied subsequently. And this is a federal court case. Following this case, this is essentially a case law that has been followed by the courts subsequently. Okay, so I'm going to now explain, or rather go through case studies on variation of maintenance terms in situations whereby there is a material change of circumstances. And very briefly, I'm going to be going through two cases. The first one whereby variation was granted, and the second one whereby variation was not granted. In the case of Anna Tay Siew Hong, what happened was in 1986, the wife obtained a maintenance order which required the husband to pay maintenance of 500 ringgit to the wife. Subsequently, in 1994, the husband filed an application to rescind the maintenance order due to the following reasons. One is that he was at that point in time quite elderly. He was 60 years old. He was in poor health and had a variety. He no longer had a permanent job, and he had subsequently remarried and was depending on his new wife for financial support. So because of the extent of the circumstances in which there was a change, the High Court said that looking at the varied circumstances, this was sufficient to be deemed a material change in circumstances, which allowed the court to then rescind the maintenance order. So basically, the court essentially removed the maintenance order for the wife, and the husband was no longer required to pay the 500 ringgit per month. Now, this case of Karen Young, the court did not grant the order for variation, which was applied for. And basically what happened was that in 2012, the wife obtained a maintenance order which required the husband to pay monthly maintenance of 800 ringgit for the child, with an increase of 1,200 to 1,200 ringgit from January 2013 until the child turned 21. In 2017, the wife subsequently applied to vary the maintenance order, and the wife's basis for so doing was basically, she said that there was an increase in school fees and other curriculum activities. And the wife argued that this was sufficient to be a material change in circumstances, as the child had grown up, and because the child was now a teenager, she had greater needs both in school and in his upbringing. The wife also alleged that the child had to be enrolled in an international school due to the child's alleged dyslexic condition. Now, we use the term here alleged because there was no psychological report to prove that the child was actually dyslexic. The wife also failed to justify her reason to enroll the child in an expensive international school, which was far beyond the means of both parties, in particular the husband. And the court basically held that because this alleged material change in circumstances was caused by the wife herself and not because of a mutual understanding or a mutual agreement by both the husband and the wife, it is a self-inflicted hardship and is not enough to be a material change in circumstances. So crucially, the court distinguished between the want of a party. So essentially what the court said was, when looking at a material change in circumstances, what they will look at is that alleged change that you are referring to, is it a need or a want? Is it in the best welfare of the child? And also, is it something that both parties are able to agree on, i.e., is it something that both the wife and the husband can agree on that is required by the child? Or is it something just one party, or rather the person whom payment is supposed to be made to, is trying to enforce against the husband? And if that's the case, obviously the court will be more inclined to not allow for the variation application. I'm now going to go through two cases on variation of custody terms. And similar to the previous case studies, there will be one variation case whereby custody terms were successfully varied, and the second whereby custody terms were not successfully varied. In this case of Legastri Anak Perempuan Purna Chandran, basically what happened in this case was one party breached the custody and access terms in a Decree Nisi. So basically, as previously mentioned, under Section 97 of the LRA, crucially, in relation to children, the court will also take into consideration the welfare of the child when varying custody or access orders. So in this case, what had happened was that the wife had ignored the Decree Nisi and she had essentially left the country and took the child with her. The court deemed that this was a material change in circumstances that necessitated a variation of the terms of the decree because the husband had not been allowed liberal access to the child in accordance with the terms of the Decree Nisi. And despite the court making an order requiring the child to return back to the jurisdiction, i.e. Malaysia, the wife continued to keep the child outside the jurisdiction. So in this case, what happened was the court essentially looked at the case holistically and decided that, look, the wife is not complying with the terms of the Decree Nisi. And even though the wife had primary custody of the child, she had very clearly violated the terms of the Decree Nisi, and that warranted a variation of the terms of the Decree Nisi. And basically, the court held that the husband was entitled to vary the decree because the wife had proven herself to be unreliable and untrustworthy with regards to her obligations under the Decree Nisi, and that her actions in denying the husband access was unreasonable and detrimental to the child's welfare. So essentially, the court's primary concern was with regards to the child's welfare because the wife clearly did not prioritize the child's welfare because the child was uprooted from her family and her familiar routines. The child had been essentially living together with the wife and her unknown cohabiting partner and was effectively forced to flee the country in order to avoid the husband having access to the child. Now, in contrast to the previous case, this case of Zhu Jiji, the variation of the custody order was not allowed. And crucially, in this case, what happened was the wife was granted sole custody of the children, and it was done so that the wife could continue living in the matrimonial home with the children, and the matrimonial home would then be transferred to the name of the children upon the children attaining the age of 18. Access to the children was granted to the husband, and later, subsequently, the husband applied for a variation for a few reasons, the main one being that custody, for a few reasons of variation on the basis that the main one being custody is granted to him. There were a few other requests in the variation order as well, including the custody of the children changing hands. So basically what happened was that the wife had remarried and had another child outside as a result of a new marriage, but continued to stay in the matrimonial home with her children and her new partner, basically requesting that a variation be made with regards to the Decree Nisi. The husband alleged that by starting a new family, the wife is not capable of providing the same care and attention to her children's needs. And by allowing the new husband and the new baby to live in the matrimonial home, the wife had disregarded the welfare of the children. And lastly, that the husband is in a better position to have custody due to his stable income, with the assistance of the husband's parents to take care of the children's needs. The court held that these grounds or these reasons for variation were insufficient, as the children were effectively living in a new family environment. The family unit was complete, and it's very common for divorced couples to remarry, to have children, and to live together with children out of a previous marriage. It wasn't sufficient to justify a variation of the custody order, and the children were actually attached to their new stepfather, as opposed to the previous scenario whereby the wife's partner was unknown and unfamiliar to the husband, whereby in this case, the children are very clearly attached to the new stepfather and were attached to the new familial unit. And because of that, the court held that the present arrangement was working very well, and it didn't make sense to vary the custody order accordingly. And with that, that concludes my portion of the talk. I will now pass over to Aisha to moderate the questions portions of this talk.
Thank you, Kirthika and Rachel, for your insights. So now we'll move on to the Q&A questions. We do have several questions from the audience. Okay, so without wasting time, let's move to the first question. So the first question is that when applying for variation order, is it by way of SDK or Form 11 of the matrimonial proceeding rule? So Kirthika or Rachel? Kirthika, would you like to answer this question?
Yeah, sure. I'll answer this question. So basically, it's done by way of Form 11 of the divorce and matrimonial proceeding rules. Whoever this person is, yes, you are right in saying that it is Form 11.
Okay, thank you, Kirthika. Okay, so now we'll move on to the second question, which is that where the husband and wife do not have kids, the wife then requested the husband to pay the maintenance every month until she remarry. Would Section 84 apply to the spouse that remarry? For example, let's say the husband can stop paying the ex-spouse the monthly maintenance fee if the husband marry another woman. So that is the question.
Hi, Aisha. Thank you. To the person who posed this question, I'll give you one answer for each situation. I'm not really sure which one you were pointing to. So the first situation is whereby husband and wife, husband is to pay wife a particular amount each month. So say if the wife remarry, the wife being the person receiving the maintenance, remarries, the wife's right to the maintenance will stop. This is pursuant to Section 82 of the Law Reform Marriage and Divorce Act 1976. You can look it up. So the second situation is whereby husband and wife, husband paying the wife a particular amount each month, but the husband is now deciding to remarry. So for this situation, the maintenance doesn't stop, not pursuant to any act. However, the husband can apply to the court, as Kirthika has discussed very extensively just now, for a variation order to vary this maintenance term for the payment to the wife. However, the husband will need to prove to the court that this remarriage will cause him financial difficulties, that he is unable to meet the maintenance terms. So this goes back to material change in circumstances. The husband will have to prove that before obtaining a variation order from the court. So I hope this answers your question.
Thank you, Rachel. Okay, so the next question is that someone asked, is there a limit to child maintenance, for example, up to the children's age of 18?
I'll take this one, Aisha. So previously, actually, it was until the child was reached the age of 18. However, after the amendment of Section 95 of the Law Reform Act, it is now up to the completion of the child's tertiary education. So effectively, university, so that would be degree. So after the amendment, except for where an order for custody or maintenance of the child is expressed for a shorter period. So unless, for example, it's a case whereby both parties are agreeable that the maintenance order is for a shorter period of time. So for example, either until the child is 18, or for example, one we've seen before is until the child completes their A-levels, for example. So except where it's a voluntary agreement, usually it will be until the child reaches the age of I believe there's actually also one more question similar to the question that has already been posed. Aisha, do you want to read out the question? Then I can.
Yeah, okay. So the question is I think it's almost similar. The question is that whether the maintenance is still payable to the child who has attained the age of over 21 years old. So whether the husband can be ordered to pay until a child completes his university.
So it's basically just pretty much as above. Essentially, yes, unless there is some sort of agreement that it's a lower age, for example, as previously discussed, if it's A-levels or 8.
If I may just add on to that, for the amendment, it amended to add on the words pursuing further or higher education or training. So I think one question that most people will have is, oh, what happens if my child doesn't pursue higher education or doesn't pursue higher training? So then it will fall back onto the first few sentences of the Act, which states that it shall expire on the attainment by the child of the age of 18. So this is something to look out for, especially when you are drafting your joint petition. Yeah, so perhaps this is something to look out for while drafting the maintenance term. Yeah, I think we have one last question from Ms. Lee here. So it states that up till tertiary education, what happens if the child proceeds to master's or PhD, which is also tertiary? Does maintenance cover master's or PhD? This is not specifically stated in the Act, but there are case laws on this, and it is up to the first, if I'm not mistaken, I will need to double check on this. It is up to the first postgraduate degree, if I am not mistaken. Say the child were to do 3 or 4 masters or 3 or 4 PhDs, it will be limited only up to the first one, because at the end of the day, child maintenance will have to, it does end, it does cease. If you have any more questions regarding variation or enforcement, please post your questions into the Q&A. We have another question. I believe this attendee will probably be a lawyer. Under what circumstances would you apply SDK? SDK being, for the lay people, it's called summons in chambers. In Bahasa, it's called saman dalam kamar. That's why it's written as SDK in matrimonial proceedings. So it states that there are case laws or authorities that use SDK to apply for VO. Is that Form 11? Rule 56 talks about ancillary relief like maintenance orders, property division, whereas Rule 91 is about SDK. I think it would be better for you to maybe contact us directly, because this requires quite a long bit of advice, and I don't think it would be fair to answer this in this talk. Maybe you can drop us an email. You can find our email addresses at the Mawingkwai website, and we can discuss further regarding this. I think that would be more appropriate. Another last question. How long is the procedure from Decree Nisi to absolute and the court order? Okay, so there are two kinds of circumstances. There are circumstances where at the pronouncement of Decree Nisi, the court decides to make it absolute immediately. So on the same day, your Decree Nisi will be pronounced as absolute. The second circumstances, this is pursuant to the Act as well. It is a period of 3 months between Decree Nisi and Decree Absolute. If you want to ask me the procedure of the full divorce proceedings, I would say 4 to 6 months for joint petition. This is if the court has 3 dates for hearing. And the Decree Nisi and Decree Absolute itself is the court order. So there is no period between Decree Nisi or Decree Absolute to the court order. I hope that answers your question. Aisha, I think we've gotten all the questions that we can get today.
Okay, thank you, Rachel and Kirthika, for answering the questions. I will have several announcements be made before we conclude our today's talk. Okay, so firstly, our next talk is on the 12th of July, 2023, on the topic of contentious probate proceedings by our very own Chu Moon Wei. So please feel free to join us. You can scan the QR on the screen or sign up on the link as stated on the screen as well. Secondly, do follow our social media. We are available on YouTube, Twitter, Instagram, LinkedIn, and Facebook, as you can see from the links on the screen. And thirdly, we do offer a complimentary 30-minute video consultation with our lawyers. You can scan the QR or you can just copy the link and fill the form here. Okay. So thank you everyone for joining today's talk, and please feel free to join our upcoming talks. And thank you once again, Kirthika and Rachel.